You may now be seated. This court is now in session to hear the case of Diong and Anor versus Amalan Tepat Sdn Bhd reported in 2008, 3 MLJ 411. Encik Diong and Puan Anor, this condominium is actually a part of our Formosa Villa di Agua project, and it will be completed within 36 months according to the scheduling H agreement, and everything is aligned with the requirements imposed by the Housing Ministry. We reviewed the sales and purchase agreement. Everything looks good and we agree to proceed.
Yes, we will make the payment of 57,000 as you required.
Okay,
Under Schedule H of the Sales and Purchase Agreement, the developer was legally required to complete the condominium and deliver vacant possession within 36 months. By October 1998, the deadline for vacant possession had passed. Years went by, yet the project showed no progress. What was promised as a home became an abandoned site.
The site is completely abandoned. There's no worker, no activity, there's nowhere near completion.
We trusted them, now we're stranded.
So under Schedule H of the Housing Developers Regulation, time is clearly of the essence. The developer was supposed to complete the unit within 36 months and deliver vacant possession by 14 October 1998, but they failed to do so. So in March 2004, both of you issue a formal letter of demand, giving them until 8 May 2004 to complete the unit, but they ignore it. Legally, that gives you the right to terminate the agreement and to claim a full refund together with LAD.
So we can take legal action?
Yes, the law is on your side.
With no resolution from the developers, the plaintiff brought the matter before the court to seek justice under the law.
The court rise for the judge. You may now be seated. This court is now in session to hear the case of Diong and Anor versus Amalan Tepat Sdn Bhd reported in 2008, 3 MLJ 411. The court will now proceed.
Yang Arif, the developer failed to complete the condominium by the contractual deadline of 14 October 1998. The plaintiff waited more than 5 years. Despite that, they still act reasonably. But on 8 March 2004, they issue a formal letter of demand requiring completion and vacant possession by 8 May 2004. The defendant took no action. Yang Arif, this is clear breach of the sale and purchase agreement. The plaintiff therefore lawfully terminate the agreement. Now I call the first plaintiff. Encik Diong, did developer ever complete the project?
Never. We paid 57,000 ringgit, yet the building left abandoned and there was no progress for years.
I call the valuer.
Upon inspection, I can confirm that the project was abandoned. There was no construction activity. The plaintiff suffered financial loss due to prolonged delays.
Yang Arif, the delay were caused by unavoidable circumstances. The developer faced serious financial difficulties and severe shortage of materials. These factors were beyond their control. We asked the court to consider the pressure and challenges in the construction industry. I called the managing director.
We never intended to abandon the project. We encountered financial constraints, supply disruptions, and internal contractual disputes. These impeded progress. We were trying to resolve them.
I now called the project manager. The delays were caused by weather, supply issues, and funding shortage, making the project difficult to continue. It was not deliberate negligence.
Yang Arif, the developer shall pay immediately liquidated ascertained damage. No notice is required. After years of waiting, my client lawfully terminate the agreement. They are entitled to a full refund together with LAD.
Yang Arif, the delay should be viewed in context. The plaintiff waited too long before terminating. They gave no earlier notice. They did not make full payment. Therefore, LAD should not be applied.
After considering all the evidence, the court finds the following. This is the essence under Schedule H. Liquidated ascertained damages are automatic when delay occurs. The plaintiffs were entitled to terminate the SPA and are entitled to a full refund of 57,000 ringgit Malaysia as well as LAD calculated up to the termination date. Having considered the evidence and submissions of counsel, the court's judgment is entered in favour of the plaintiffs. Amalan Tepat Sdn Bhd shall refund all payments and pay LAD to plaintiffs with interest.
Well, at least the justice has reached us today.
Overall, this case confirmed that housing law prevailed over private contracts. When developers breach their obligation, the law protects home buyers.